Hi, my name's James Sheedy. I'm a litigation partner in the private client and trust team at Collis Krill based in Jersey. For those of you who don't know us, Collis Krill is an offshore law firm practicing in Jersey, Guernsey, Cayman, BVI and Bermuda. And our discussion today is going to be on the topic of the variation of offshore trusts. Much of my work as a practitioner concerns contentious and semi-contentious situations involving a range of offshore private wealth structures, including offshore trusts. And as I say, the focus of our discussion today is going to be towards the semi-contentious end of my practice, which is the jurisdiction of the courts in various offshore jurisdictions to vary or amend the terms of the trusts over which they have jurisdiction. So we're going to be looking at the reasons why you may need to vary an offshore trust. There are some similarities that many of you will be familiar with in terms of reasons in the onshore context, although there are some specifically applicable rules when it comes to offshore trusts that you should probably be aware of. We'll be looking at the key similarities between the jurisdictions and how the court approaches requests to vary, and we'll be looking at some of the differences to bear in mind and the potential significance of those differences when it comes to picking a governing law for your trust structure. So, by way of introduction and a bit of context, an offshore trust is simply a trust that is typically settled under a combination of the governing law of an offshore jurisdiction. Typically that will be somewhere like Jersey, where I am based, or Guernsey, Bermuda, Cayman, all manner of offshore jurisdictions, and the trustee of that trust is based usually in that jurisdiction or potentially another offshore jurisdiction. So sometimes you can get a Jersey-based trustee of a Guernsey law trust. Offshore trusts have been established for decades as a governance framework for assets in what are largely tax-neutral jurisdictions. Trusts in both the offshore and onshore world are intended to last often for decades, and in jurisdictions like Jersey and Cayman that don't have an upper perpetuity limit, they may last theoretically at least indefinitely. And you can contrast that with jurisdictions like England and Wales, for example, where there is a maximum perpetuity period of, say, 125 years. And that fact that there is a limit in that perpetuity period is often, in some of the old case law in the onshore world, a reason to vary the trusts. So that's not tends to be a feature in the offshore world. But as long-lived structures, we all know that offshore trusts inevitably come under strain when they're faced with circumstances or developments in the real world that are very different to those that may have been foreseen when they were first created. And that's really what we're looking at in terms of the reasons why you might vary an offshore trust. Some of the themes as professional advisors that we're encountering when we review older structures are looking at adapting outdated, inflexible or inadequate drafting that doesn't suit the requirements of the modern world. The simple reason why you may wish to adapt or vary your structure is that if you don't do so, it can leave the trustees unclear about what their obligations are, and that will leave the structures that they're responsible for vulnerable to risk and disputes which are best to be avoided.